Hearing in the Queen on the application of B against Secretary of State for the Home Department.
Mr. Tam, before we begin, the court does propose to make an anonymity order, but not in the terms that have been agreed between the parties, for the very obvious reason that one of the major objects of the proceedings at an earlier stage has been to get the respondent to identify himself. So it seems like not a good idea to prohibit that. But what we propose to order, unless persuaded to the contrary by any of you, is that for the purpose of these proceedings, the respondent shall be referred to only as B. Does that meet with your approval, Ms. Harrison?
Yes, my lady, it does. The form of order that was provided to us included nothing that could lead to the identification of the respondent or any member of his family, and we would certainly want to.
Well, if we just refer to him as B, if he is referred to as B, I think we can leave the matter as that.
So be it.
Yeah.
Lady, I'm grateful. May it please the Court, in this appeal, I represent the Secretary of State together with my learned friend, Ms McCrae. The respondent is B, and he is represented by my learned friends, Ms Harrison and Mr Vaughan. The Secretary of State was technically the interested party in the underlying judicial review. The defendant was the Special Immigration Appeals Commission. They don't appear and they aren't represented in the conventional way. But the court does have the benefit of an appearance by an intervener, bail for immigration detainees, who are represented by my learned friends, Mr Fordham and Ms Stubinsky. I fear, lady, that we will end up calling them BID all the way through, but I hope we'll be forgiven if we use that shorthand.
Well, it's only they who need to forgive you. The rest of us don't mind.
The anonymity order was the first of the housekeeping matters that I had to mention. The second was that we're grateful for the communication from the court about the timetable. In the light of that, I should perhaps tell the court that what my learned friend Miss Harrison and I have agreed to do is to each lop off a quarter of an hour from our openings. Also, having noted the adjective generous used in that email, I, for my own part, will try and regard the time I've allotted, I am allotted as a target, not so much as a target, but an absolute maximum, and try and keep my submissions more concise than that if I can.
Thank you very much indeed, Mr. Tam.
The final matter is that there is, or there should be, a copy of a slim ring binder that looks like this, which is intended for additional authorities. There are already 4 in there, and I hope that we won't have to refer very much to them, but I thought I should just identify that is there.
Well, this, as I recall it, was Mr. Fordham's suggestion that there should always be an additional slim ring binder.
Indeed.
In authority-heavy cases, or at least almost every case, somebody finds something that hasn't been copied, and into which we can then slip the additional ones. So Mr. Fordham should get the credit of that idea.
Lady, indeed, it's only one of Mr. Fordham's great ideas for the smooth running of this court, and so we are indeed grateful. Turning to the appeal itself, the twists and turns in B's case would be worthy, actually, of an Agatha Christie novel. The procedural history is extremely complex. There can't be many individuals who can claim to have had a case before a court at this level, twice in the House of Lords and now twice before this court, so a total of 4 times in their lifetime. Because it is so complex and because it has been comprehensively set out in the statement of facts and issues and in the cases, so far as is relevant, I don't propose to say very much more about that, except to identify that since the statement of facts and issues was agreed, the deportation proceedings have now come to a final end, and B is therefore no longer subject to deportation action at this time. That, of course, doesn't detract from the importance of the point of principle, which was raised by the Court of Appeal's judgment in this case. and it is therefore on that we focus. The additional...
You say on that you focus. For the future, hasn't the position been resolved by the amendment? So, in truth, this is a historical problem which no doubt may have some consequences in terms of claims, outstanding claims.
Well, that's an open question. The court kindly indicated that it wasn't going to require us to argue about Section 61, but there would have been, we think, at least 3 questions about Section 61. First of all, whether it is effective to do what it was intended to do, which is to reverse the Court of Appeal's decision. The second that I can immediately think of is the ambit of Section 61. The reason I say that is this, that B's case arises in the context of Hardiel Singh unlawfulness, detention that has, to put it shortly, gone on for too long. There are, of course, other types of unlawful detention. And if one follows through the logic of what the Court of Appeal said, it would apply also to other types of unlawful detention, which may or may not be covered by Section 61. I really don't want to say more than to identify the possible issue. And there is a third issue, which is the extent or the effectiveness of the retrospectivity provision, which could be argued about. So that this is not academic. And in fact, one of the additional authorities it actually illustrates exactly why it isn't. Perhaps I can just go straight to that. It's the ring binder at tab 2. I should say tabs 1 and 2 are the cases of Jolla and Lupepe, both heard by Mr. Justice Lewis at the same time, but he gave 2 separate judgments. They concern the rather vexed issue of bail curfews. That's to say somebody who is granted bail and has included a curfew condition, so they have to be at home for certain periods. There was a time when the Secretary of State was using the power of temporary release to impose curfews. That's been held by the Court of Appeal to be an inapt power. It didn't allow curfews to be imposed, so the curfews were unlawful. And tab 2, in the case of Lupepe, what happened was that as part of the fix for that, individuals who had been on unlawful curfews were detained very briefly, literally for a matter of seconds, and then granted bail from that. One of the arguments that was raised was that if Mr. Lupepe was detained at all, then Chapter 55 of the EIG, the detention policy, should have been applied to him. If you go to paragraph 70, under the 4th issue, you see what Mr. Justice Lewis made of this. The argument is set out at paragraph 70, failing to comply with the provisions of Chapter 55. For present purposes, I think all I need to do is to note that at 71 to 72, Mr. Justice Lewis rejected that. He said that the Chapter 55 was not applicable, so the brief detention was not unlawful for that reason. But then at 73, what's important for our purposes, he says, for completeness, I note that if, contrary to my conclusions, the detention had been unlawful, then the curfew would also, in my judgment, have been unlawful. Curfew was imposed as a condition of the grant of bail. Power to grant bail, and hence to attach conditions, only arises if there's a lawful detention. That is consistent with the decision of the Court of Appeal in B. Algeria. Mr. Tam submitted that this decision is applicable only where detention is unlawful because there's no realistic prospect of the claimant being removed. That was the reason why, in that case, that continued detention was unlawful. The logic of the reasoning of the Court of Appeal, however, is not limited to such cases of illegality. If the detention in the present case had been unlawful, then there would have been no power to attach a curfew condition as a condition of bail, and indeed no power to grant bail at all. So that's why it is of continuing importance. May I then introduce the issue by showing the court the statutory power that is at the centre of this appeal?
Well, basically, what this case is about is the construction of the word detention in the relevant provisions, is it not?
It's a little bit more than that, but can I show you, because I want to go straight to this, so I can show you what the problems are. It's Authorities Volume 1 at tab 4, and can I go straight to page 101 of the print, which is MS 717. Paragraph 16 of Schedule 2 to the Immigration Act 1971. Paragraph 16 is the detention power, and this is the start of the logical reasoning in all of this. You'll see that at subparagraph 1, a person who may be required to submit to examination may be detained under the authority of an immigration officer pending his examination, etc. And this is the format that's used in almost all of the detention powers in the immigration sphere. You'll see that the subparagraph is not itself authority to detain. It's a power that allows an immigration officer to give authority to detain. And that is, of course, for actual detention. And what we know from the case of Kadir is that that power continues to exist so long as there is some prospect of the end point being reached. Just for your note, Kadir is at Authorities 2, tab 13, MS 1070. Can I then go on from there to paragraph 21, which is page 107 of the print MS 723. Now, this is the power of temporary admission, which was directly an issue in Kadir. And it
Paragraph 21.
paragraph 21,
723.
page 107 of the print. A person liable to detention or detained under, and then the powers are identified, may, under the written authority of an immigration officer, be temporarily admitted. So that, in its actual wording, identifies two categories of people, people who are detained and people who are liable to detention, and they can be temporarily admitted. And what we say about this is that on the face of those words, that is a reference to the time at which temporary admission starts. So liable to detention or detained is in effect a condition precedent to the power to temporarily admit. What 21 doesn't itself have is any indication of how long that power continues for. But to make sense of it, the case of Kadir held that that continues so long as there is some prospect of removal, because it is during that time that the person remains theoretically subject to detention powers.
I mean, Kabir means that you can be liable to detain even though, because you may be detained under Section 16, is that right? Even though you can't be detained because
yes,
of Hardil Singh.
The construction of liable to detention was that the detention power exists, and even if it cannot at that time be exercised in relation to you. Going on then to paragraph 22, which is the key provision in our case. This is on the next page, page 108 of the print MS 724. It's in very similar terms as far as structure is concerned, and it's the following, namely a person detained under paragraph whatever, and the three of them are set out there, may be released on bail in accordance with this paragraph. But what is notable is that adopting the same structure, this again refers to the moment of the grant of bail. It allows release on bail, but the provision is silent about how long this power continues for after that point. So that is why I demurred a moment ago from saying it's just a question of the word detained, because there are actually two questions here. The first one is, when can the person be released on bail? And the second is, when that power has been exercised and the detention has been ameliorated by release on bail, for how long can bail continue? I don't think I need to turn them up, but can I, for completeness, note that there is another bail power at paragraph 29, which is page 136 of the print MS 752, and that is a power for bail pending appeal. As we've observed in our printed case, the wording of that makes even clearer that it refers specifically to the moment of release. And also, directly relevant, but we don't need to look at it, is Schedule 3, Paragraph 2, which is on page 144 of the print MS 760. The reason for mentioning that is because that actually contains the powers of detention in relation to deportation cases, and of course B was a deportation case. And then subparagraph 4, capital A, then applies paragraph 22 to deportation cases, and that's how paragraph 22 becomes important.
Sorry, just say that last bit again, Mr. Chairman.
Yes. Schedule 3, paragraph 2 relates to deportation cases, and it's paragraph 2, 4A, that applies paragraph 22 of Schedule 2, that bail power, to deportation cases. So that actually just explains why we're looking at paragraph 22 when, on the face of it, it doesn't deal with deportation. So coming back to the two questions I identified a moment ago, our case, in a nutshell, is simply this. The power to release on bail arises simply if you are detained under one of the relevant powers. It matters not whether your detention is lawful or unlawful at that time, because the whole idea of the power to release on bail is to get you out of detention. The second, or the answer to the second question is that although the statute is then silent about how long the bail power continues to exist, by parity of reasoning with Qadir and the purposive approach taken in Qadir, the bail power must continue for as long as the power to detain continues to exist. Or in other words, so long as the immigration process is in train. In contrast, B's case is that the statute must have two things implied into it. The first is that as far as the release on bail is concerned, the word lawfully has to be injected into that paragraph to qualify detained. So that if you are detained, but there is some kind of legal defect in your detention, however trivial, the bail power simply does not exist at all. We say that that is simply not found in the statute or in any reasonable approach to how the statute ought to work. And B's answer to the second question is fundamentally that the bail power continues to exist only so long as the circumstances are such that if the Secretary of State wanted to re-detain, it would be lawful for her to do so. That is to say, at every moment while bail or the person is on bail, you need to ask the question, would actual detention at this time be lawful? And you have to ask that even if nobody is proposing to detain the person at all. So that is the issue which the court has to decide. And we respectfully say the construction which we proffer is one that makes sense. It doesn't offend against any principle if you think about what bail is supposed to do. In contrast, if you follow B's argument and the Court of Appeal's decision, you end up with an immigration system which is full of even more complexity than it has at the moment. And that is a result which we say, with respect, this court should not reach. Having introduced the issue, can I make two preliminary points? The first is that this case has never directly been concerned with the first time point. That is to say, whether detention was lawful at the point of B's release on bail. As the court will have seen from the chronology, B was released on bail certainly no later than early 2011. In January 2011, he went to bail accommodation. He then had a brief spell in hospital the following month, and then in March 2011, he went back into bail accommodation. Nobody during these proceedings has raised the question of whether detention was lawful or unlawful at the time of his release on bail. And that has shaped the argument in the courts below. The argument had always been about how long the bail power could continue for, and not about the initial point at which he was released on bail. And the reason I mention that is because a lot is made in B's case about the reference to Qadir and the differences between the language in paragraph 21 and paragraph 22. With the argument that Qadir only deals with paragraph 21, which is liable to be detained. The reason that I mention that is because now that we are looking at the whole time period for which the bail power exists, including that initial moment of release on bail, there are obviously a lot more considerations to go into it than that. But the judgments below, and particularly the decision that SIAC reached, has to be seen through the light that, or the lens of the fact that everyone was looking at continuation, and nobody had really focused at that stage on the point of initial release. The second preliminary point is this, that this is not an appeal about the conditions of bail. There is a lot made in B's case about the stringency of the conditions of his bail from time to time. But so far as the question of statutory construction is concerned, that is all irrelevant. B's argument and the Court of Appeal's decision apply just as much to unconditional bail, if one might call it that. Of course, we know that bail always has a condition that you must appear at a certain time and place to surrender to your bail. But other than that, it's possible for bail to have no conditions at all. And the argument applies equally to that. We respectfully say the court should be careful not to decide this case as if it were a disguised complaint about the stringency of the conditions which have been imposed on B from time to time. It's about the existence of the power. Having done that, can I then just explain where I'm proposing to go with my submissions? The first thing I would like to do is to look at the Court of Appeal's judgment and then to give the court 7 reasons why we respectfully say the Court of Appeal was wrong. And then the last part of my submissions will be to touch briefly on Article 5, but Article 5 is really B's argument and it's new. So it may be that what I have to say will be more usefully said in reply than initially. So can I do the first part of it, which is the Court of Appeal's judgment? That is, of course, in the core volume. It is at tab 9, which is part 1 of the appendix, starting at page 4. The MS number is 212. As you can see from the heading, the Court of Appeal actually had 2 sets of proceedings before it. One of them concerned a strikeout application made by the Secretary of State to strike out B's appeal. We're not concerned with that at all. We're concerned only with the bail appeal, which you find dealt with from paragraph 17 onwards. That's page 12 of the appendix, MS 220. The Court of Appeal started off by setting out the statutory provisions over quite a number of paragraphs. And then at paragraph 23, page 14 or MS 222, it's under the heading, the issue, it said the starting point is SIAC's ruling in February 2014 that there was, quote, no reasonable prospect of removing the appellant to Algeria, and thus the ordinary legal basis for justified detention of B under the Immigration Act has fallen away. The Secretary of State accepts that there was thereafter no further authority for the detention of the claimant under paragraph 2.2 of Schedule 3. So that's a detention power. Can I just pause there, because with respect, this needs to be unpacked slightly. It's clear that SIAC decided that the Hardy-Singh limit had been reached. It stated its conclusion in clear terms, even though B was not at that time detained, and he had not been detained for about 3 years by then. But the next sentence is a little Delphic. There was thereafter no further authority for the detention of the claimant. Now, we know from Kadir that the power to detain B continued to exist throughout this whole time because deportation action was still in progress. So the question arises as to what the Court of Appeal meant by the words, thereafter no further authority. If what they meant was that there was a constraint on the Secretary of State's ability to exercise the detention power which still existed, then it is important to note that that is the limit of the lack of authority to detain. It was not a cessation of the detention power, but it is possible that what the Court of Appeal meant was that there was no further authority in the sense that the Secretary of State did not or had not authorised further detention.
Or had not in fact, you mean? Or could not?
No, had not, and I suppose included in that, could not give further authority. But the tense used is there was no further authority, which suggests that they're referring to the actual position as from February 2014 onwards. Now, as a matter of fact, that is correct, but that's only part of the picture. B had been on bail since 2011, and there'd been no authority for his detention since 2011 because he'd not been detained since 2011. And so it is really quite unclear what the Court of Appeal meant when it said, no, thereafter, no further authority.
Well, isn't it explained in the next sentence? It is the Hardy-Singh point.
Well, that might be what they meant, but it is not clear that it's what they meant. And the reason for that is because, as a matter of history, what B then did after February 2014 was he brought judicial review proceedings, which are in form the judicial review proceedings before this court now. But initially, they were brought against the Secretary of State's continued authorization of B's detention. And we pointed out that that was actually misconceived. There was no authority no authorization for his detention because he wasn't detained and he hadn't been detained and there hadn't been authority for years.
So you're suggesting, are you, that the word authority in the 5th line of that paragraph should be read as order rather than legal basis for?
Well, if that's what the Court of Appeal meant, then yes, that would be a more apt description.
But doesn't, as has been pointed out, doesn't the following sentence rather suggest it should be read as no further legal basis for?
Well, the following sentence, common ground that the claimant could not lawfully be detained, is an accurate statement of the position under Hardy-Singh. Once you've reached the Hardy-Singh limit, you can't exercise the power to detain. But as far as the other two things are concerned, the power to detain still existed. So if the Court of Appeal thought that authority was
the potential power, I mean, it's all very confusing, but Hardy-Singh means you can't immediately detain, but Kadir means that potentially you may be able to detain if circumstances change.
Yes, the power to detain exists, but you can't lawfully exercise it. That's Kadir.
Yes.
This is just one of the complexities we already have in the system, but Kadir is quite clear that is the conclusion.
It cannot presently exercise it, isn't it?
That's right, yes. So there is that oddity there, and the reason that I highlight it is because there are passages in B's case which suggest a misconception that there has throughout this period been continued authority to detain, or there had been authority to detain actually given by the Secretary of State up until February 2014. And I need to be at pains to stress that cannot be right, because he had not been detained for years by that time. And as we know, authority to detain doesn't just carry on indefinitely. It has to be renewed and refreshed from time to time, and that's Kambadzi, indicating the importance of detention reviews. So going on from there to the Court of Appeal's actual reasons, at 24, 25 and 26, there's a statement of the parties' cases and a description of SIAC's reasoning. And then at 27, the Court of Appeal's own reasoning starts. First of all, they said that they identified Kadir was not a case about detention, and 28, they identified that it's about the power to grant temporary admission. And we respectfully say that while that's right, that misses the point, because that is a focus on the point at which either bail or temporary admission starts, and it doesn't address the question of how long it goes on for. At 29, the court accepted learned friend Ms. Harrison's submission that it was not apt to apply the Kadir reasoning to bail for the linguistic reasons then set out in 29 and 30. And then at 31, there is the court's conclusion that bail may not be granted where a person is unlawfully detained, or where a person not currently in detention could not lawfully be detained. And then the reasons are then set out in the following paragraphs. Essentially, 4 reasons are given. Paragraph 32, there's the proposition that the statutory provision had to be construed restrictively, and that came to the conclusion that it should be detained should be construed as lawfully detained. At 33, there's reliance on 2 old cases supporting a bald statement that the power to bail presupposes the existence of and the ability to exercise the power to detain lawfully. At 34, there is with respect, simply a statement of a belief that Parliament had intended the construction that had been, that was preferred by the court. And then at 35, there's a rejection of arguments which the court described as based on impracticability. In the light of the argument which this court has and will have from all of us, we respectfully say that that was not a particularly penetrating set of reasons for coming to the conclusion that the power had to be construed in the way that the Court of Appeal said it should be. And what we now go on to do is to identify 7 reasons why, with respect, the Court of Appeal was wrong to reach that conclusion. The first is that the statutory language does not limit the circumstances of the existence of the bail power in this way. The second reason is that our construction is consistent with the purpose of the bail power and with the approach to the temporary admission and temporary release power decided by the House of Lords in Kadir. That is to say, bail should be available throughout once it is granted. The third reason is that bail is an ameliorating power to relieve someone from detention. So the interpretative principles taken by B from Annis Minnick and Lumber do not need to be applied in this context. The fourth reason is that the consequences of B's argument would lead to a scheme that is impracticable, to take the Court of Appeal's words. It is so complex that it could not have been intended by Parliament when passing the Act. The fifth reason is that if you look at the effect on other kinds of unlawfulness, other than Hardy or Singh unlawfulness, B's argument and the Court of Appeal's conclusion leads to absurd results. The sixth reason is that the old cases on which the Court of Appeal relied were, and they were always, a red herring. They simply don't assist because the concept of bail today, and at the time that the 1971 Act was passed, was different, in fact, almost the opposite, from the concept of bail at the time those cases were decided. And the Court of Appeal should have placed no weight on them at all. And the seventh reason is that the Court of Appeal's decision upset a long understanding of the relationship between unlawful detention and bail. And we can see from cases which, we admit, don't determine the point before the court, but cases which illustrate how many judges have regarded release on bail, sometimes on stringent conditions, as an appropriate remedy for detention which has become unlawful. In other words, bail is useful in exactly the way that the Secretary of State contends.
The background to much of that is that there is a difference between the conditions that can lawfully be imposed on the grant of bail and the conditions that can lawfully be imposed on the grant of temporary admission. That's a given, I take it.
Yes, and
you can be stricter in bail conditions than you can in temporary admission.
That's right.
That's common ground, is it? Yes.
That is common ground. I entirely accept that, and that is part of our purpose of approach. But it doesn't detract in any way from the point that I made earlier, that in principle the construction arguments apply equally to unconditional bail, and somebody could end up on unconditional bail if they've been on bail for a long time and conditions have gradually been relaxed over time. But as a matter of how it works in practice, I accept bail is something which is often going to involve conditions of more stringency than can be imposed under TA.
Is there also a difference in the sanction for breach?
There is, but we don't place any reliance on that ourselves for the construction. That there are different sanctions.
No, but in practice, what's the sanction for breach of a temporary admission condition?
That is prosecution, and that is what the statute provides. Whereas if you breach your bail, you could be arrested and brought before an immigration officer or the tribunal, and then there will be consideration of whether you should be granted bail again.
Thank you.
So reason one, the statutory language. We deal with this in section 4 of our case that starts, it's tab 6 of the core volume starting at page 13, it's MS 132. I say that because some of what we say there I have already said in identifying the issue, and I'm not going to repeat what I've already said. I would, however, ask to draw attention to the chronology of this, which is relevant in considering whether Parliament can have intended the complexity which B urges on this court. The 1971 Act was passed on the 28th of October 1971. It came into force on the 1st of January 1973. It's a date I think we're all now very familiar with, and it wasn't coincidental. But that, as a matter of history, was when it was. But Hardial Singh, the decision of Mr. Justice Wolfe, as he then was not decided until the 13th of December 1983. So almost 11 years later. We accept, obviously, that common law limitation on the ability to exercise the power to detain must be taken always to have been present. But it had not yet been clearly articulated as it then was in Hardial Singh. And so we do pose the question of whether Parliament would have intended, when passing the Act, to inject that qualification of lawfully detained into the condition precedent for the grant of bail. We respectfully say that is, in the light of that chronology, unlikely.
Well, is that right? I mean, if one assumes that Parliament didn't realise that Hardial Singh was coming, it would have assumed that it was possible to detain lawfully as long as there was some prospect of removal. And on that basis, there would be an actual detention unless bail was granted. So it wouldn't have seen the need to be able to grant bail in respect of unlawful detention, because it wouldn't have contemplated, at least in the Hardial Singh context, that the detention would have become unlawful.
I think the way that I would put it is this. Hardial Singh not having clearly articulated that limitation on the exercise of the power, if you then cast your mind back to what Parliament thought it was doing in 1971 and what it intended, here you are, you've got an unqualified bail power. Parliament clearly foresaw that there would be people who were actually detained who ought not to remain actually detained. And so the tribunal or an immigration officer, then I think an adjudicator or the immigration officer, would be empowered to step in and terminate the detention by granting bail.
Well, why would it have? I mean, you mean it just would have generally foreseen that there would be some people who, for some reason, were unlawfully detained, even though it wasn't on Hardial Singh grounds, or what?
No, what I'm saying is that Parliament foresaw that there would be people who were detained who ought not to be detained, and that's why Parliament provided the power to get these people out of detention by bailing them. And what we say is, with the silence on the question of whether detention had to be lawful detention, and with the fact that Hardyal Singh had not yet articulated that the difference between detention which had gone on for too long and become unlawful and detention that wasn't unlawful, it is much more likely that what Parliament intended was simply, here's a man in detention, he shouldn't be there, get him out, without drawing a distinction between whether the power existed only if the detention was lawful. And that's the significance of Hardyal Singh coming much later. The other point to note about the actual words of the statute themselves is that the silence about how long the bail power continues once it has been exercised is not simply a matter of sloppy drafting, because detained can only be read as detained at that time. And as soon as the person has been released on bail, that condition of detained ceases to be satisfied. So there is inevitably an exercise of asking, well, what did Parliament intend so far as the duration of the bail power is concerned? The obvious one, we say, is that the bail power then continues for as long as the person is being dealt with by the immigration system at that time, the deportation in B's case. That's simple, it's straightforward, it's easy to understand, there's no difficulty with it whatsoever. The construction that B urges on the court is a rather more complex one, that at every moment during the continuation of bail, you have to be able to ask and answer the question, would it be lawful at that moment to re-detain him, even if nobody is proposing to do so? There are other indications in the statute that we respectfully say point to the Secretary of State's proffered construction being the better one. One example that we give is the power of arrest if somebody is going to breach their bail. Can I, for this, actually turn up the provision? It's in Authorities 1, tab 4, at page 111, MS 727.
(727).
727.
Thank you.
An immigration officer or constable, and I do draw attention to constable because it may be just an ordinary police constable who has no specialist immigration experience. Immigration officer.
Where are you reading from?
Oh, sorry, it's paragraph 24 of Schedule 2. So it's
Yes.
page
Yeah, I
111
found
of
it
the
now.
print.
Yes, thank you. Thank you.
Immigration officer or constable may arrest without warrant a person who has been released on bail if he has reasonable grounds for believing that the person is likely to break the condition of his recognizance or bail bond that he will appear, or has reasonable ground to suspect that the person is breaking or has broken any such other condition. Now, on our construction, again, this is simple and straightforward. If somebody's been released on bail, the bail is in place. If the policeman or the immigration officer thinks that the bail might be broken, that gives a power of arrest, the bail is there, and the person can then be dealt with and brought before the tribunal. On B's case, there is endless complexity, because supposing that at that point, although nobody's ever asked the question, it would then be unlawful to actually detain B because the Hardyal Singh limit has passed. It would follow from B's argument that the bail power has ceased to exist. The bail, in one sense, has ceased to exist. That's a consequence of annus minic, certainly unlawful bail. And the question arises, well, does the immigration officer or constable have a power of arrest in these circumstances? One possible answer is that the arresting officer has already ceased to have the power of arrest by this time because the bail has vanished. Another possible answer is that even though the bail has vanished, it's unlawful, and B should never have been, the individual should never have been on that bail. The power of arrest still exists, and the man can be detained under this power, even though the underlying bail has become unlawful. At the very least, that's a complex and difficult situation to find in what is intended to be a clear and swift remedy if somebody is thought to be about to break their bail.
In practice, presumably, if people are released on bail at a time when there is a reasonable prospect of removing them reasonably quickly, no one presumably monitors whether that reasonable prospect of reasonably early removal continues to exist. They presumably just remain on bail for years, do they? Or do people in practice then apply and say, look, Hardil Singh applies? Seems unlikely.
If somebody's on bail, they don't, as far as I'm aware, generally apply on Hardil Singh grounds. B was different. B did apply, and he specifically challenged his bail on Hardil Singh grounds.
Yes, but it doesn't commonly happen.
I'm not aware of it commonly
I
happening.
mean, the logic of the the logic of your position is that that's what should happen. Sorry, the logic, I apologise, the respondent's position is that yes, not your position.
That's right. That is the logic of that, and that's one of our impracticability arguments, if I can use the term. That what you end up with is a situation where somebody goes to the tribunal. Well, at the initial stage, he might say, "Well, I'm wanting bail, but actually my detention is about to become unlawful." And of course, if it is unlawful, then the tribunal's got no jurisdiction to grant bail. If after he's been granted bail, he goes back to the tribunal and says, well, I don't like my bail, I don't like my conditions, one of the things the tribunal has then got to do is to ask itself, well, would the notional hypothetical detention now be unlawful, just to decide whether or not it can continue the bail, whether or not bail can lawfully continue. And that's complicated by the fact that the tribunal has no jurisdiction to determine the lawfulness of detention. And that's now been said in many cases, including in Lumber. And so we have a situation where I think B's suggested remedy is that if an issue of lawfulness of detention or lawfulness of hypothetical detention arises in the course of a bail proceeding before the tribunal, then there should be a parallel judicial review application to determine the lawfulness of detention.
But I'm not entirely clear. I think it was clear that the tribunal has no power to determine the lawfulness of detention so as to result in the release of somebody who is actually detained. That, I think, is clear. But has it been determined that the tribunal has no power to determine the lawfulness of detention as a precondition to its own power to determine whether or not bail should be granted, continued, or whatever the conditions are? Those are two separate things.
I accept that, and I don't think that the tribunal has ever been asked to address it specifically like this. This is a leading case, and so it's going to raise all sorts of questions like that. But you don't need to think for very long to see the difficulties that brings in its train. One of the practical effects of the tribunal having no jurisdiction to determine the lawfulness of detention is that it can get on with the simple, straightforward jobs that the tribunal is best designed to do. Should this man be in detention? Should he be released on bail? What are the conditions? If you, in effect, give the tribunal not only a Hardiel-Singh jurisdiction, but a requirement that the tribunal determine Hardiel-Singh lawfulness as a precondition to its own jurisdiction to grant bail. Tribunal will be tied up in knots for ages, and that is one of the consequences, one of the rather absurd consequences of B's argument. There are 2 points in B's case which I think I should address at this stage on the statutory language. One is a question posed at paragraph 62 of his case, which is at MS 4248, which relates to where the power to either extend bail or modify conditions is to be found. B's argument, as set out in paragraph 62, is that it's necessary to have the word detained. Sorry, this is the last sentence, paragraph 62. Necessary to construe the word detained as meaning lawfully authorised detention, so that the tribunal or the immigration officer continues at all times to have the power to modify the bail that has already been granted. We respectfully say that that is a step which goes even beyond what the Court of Appeal decided. The Court of Appeal's decision, as we've seen, is that it must be lawful to detain the individual again. It must be possible lawfully to do so. What B's argument requires, so it seems, is that you actually have to regard him as being detained at all times during the currency of the bail. That, we respectfully say, is at least one, if not several steps too far, given that bail involves a release from detention. It involves keeping you out of detention. The other point which I think I should address at this stage is that in the following paragraph, paragraph 63, the reference to what happens at the end of bail. What B refers to is that bail is fixed to a point in time. That's a point at which the individual has to appear at a certain time and place. And B says, well, what happens if he's not regarded as being, as having to be lawfully detained? Well, we respectfully say that the answer is very simple, and it's a very conventional one, which is that at that point you surrender to your bail. This happens every day in criminal courts, and then you are rebailed from that point onwards. So there's no conceptual difficulty with what happens at the end of bail. There will be a brief period in nominal detention, and then a new period of bail is granted.
That's on the assumption that the original bail was until a fixed date, is that it?
Yes, but the original bail will always be until a particular time and place. That's yes. The primary condition. And in fact, both of those were decided by the Court of Appeal in the case of AR, which is Authorities, Volume 1 at tab 2, MS 600. Can I perhaps just quickly show you the relevant parts of this? The relevant paragraphs are in fact 26 and 27, which is MS 612. Just below the quote, the Court of Appeal referred to the terms of paragraph 22 as a time-honoured form of words to express the idea of surrendering to bail, once a bailed person surrenders to his bail, whether to magistrates or the Crown Court in a criminal case or to an immigration officer in an immigration case, it is then for the person to whom he surrenders to refix bail if he or she considers it appropriate to do so and to determine any appropriate conditions. And then they go on to observe that it's a necessary inference that bail conditions must cease at that point of surrender. So the problem posed by B simply doesn't exist. Can I then turn to reason number 2, which is the purposive approach to this the topic? This is dealt with in section 5 of our printed case. It starts at MS 136. It's page 17 of our case. What we say is that the fundamental purpose of the bail power is to get someone out of detention, and indeed, when they're out of detention, to keep them out of detention if they don't pose a risk that requires them to be re-detained. That purpose is served whether detention is lawful or unlawful at the point of the grant of bail.
But isn't it also a purpose to keep them on a string?
Yes, I accept it is to do that, but even temporary admission and temporary release do that. There is.
That's part of the argument.
It's intended that there should be some measure of control. I'll come on to why it's a good idea for bail powers to exist in the sense of being more stringent. But in terms of what the fundamental premise is, the very first thing is it's supposed to get you out of detention. And it serves that purpose, whether the detention is lawful or unlawful. In fact, arguably, it's more important if the detention is or is about to become unlawful.
Yes, but the statute then, as Lady Hill says, gets you on a string. It imposes conditions, and if those conditions are breached, paragraph 24, to which you referred earlier, allows the first-tier tribunal, or in Scotland the sheriff, to detain the person.
If one looks at it in Hardiel-Singh terms, given that this is a Hardiel-Singh case, what you would have is if the individual's detention was about to become unlawful and he was released on bail, perhaps on stringent conditions, and he then does something which gives rise to a reasonable, that's to say, an objectively justified fear that he can't actually be trusted on bail, that itself changes the Hardiel-Singh balance. Hardiel-Singh is not a once and for all thing. It's not a fixed time point. The question of whether detention is or would be Hardiel-Singh unlawful depends on all the circumstances at the time. And so it is perfectly possible for somebody, especially somebody who's prone to misbehaving from time to time, to find that his detention would sometimes be Hardiel-Singh lawful and at other times would be Hardiel-Singh unlawful. It could flip-flop between the two. And the misconduct which gives rise to the arrest may itself be part of that matrix. Perhaps I can put it in more concrete terms. One of the reasons why somebody might be detained is a fear that he would reoffend if he was granted bail. And there might come a point when the tribunal says, this man's detention is now Hardiel-Singh unlawful because we can't see a sufficient risk of that that justifies keeping him in detention. So he's released on bail. And then whilst he's on bail, he commits another serious offence. He does exactly that which it was feared that he might do. At that point, if you ask the Hardiel-Singh question, well, is it now lawful to detain this man because the risk of him reoffending is greater than it appeared to have been when he was released, the answer to that could be yes. And so even though the detention had been regarded as Hardiel Singh unlawful for a time, the commission of the further offence means that further detention is warranted by the fact that he has done something wrong.
Where in that analysis, if anywhere, is the question whether there is a reasonable prospect of deportation?
There must always be a reasonable prospect of deportation throughout that period. But if the question is whether at that point in time the individual can be lawfully detained, that is a Hardiel Singh question. And that the answer to that question can change one way or the other from time to time.
And so, on that approach, are you saying that the paragraph 24(3) power of the first tier tribunal or sheriff to direct detention under the authority of the arresting officer is subject to Hardiel Singh criteria?
Yes, if the person is redetained, then it will similarly be subject to Hardiel Singh.
Have we got Hardiel Singh?
Yes, we do.
You're using, I suspect, the expression Hardiel Singh in more than one sense.
That's why I'm bothered about it.
Yes. But that's
I mean, as I understand it, I think you did use, if I may say so, slightly confusing terminology then, because I think my lord was referring to Hardiel Singh as the reasonable prospect within a reasonably short time. The Cardia type prospect is there must be some prospect. It shouldn't be expressed in terms of reasonable prospect, because you're then confusing it with the language of Hardiel Singh. We've got to postulate sort of two barriers.
That's right. Hardiel Singh requires
reasonably soon,
as well.
Taking into account all the circumstances.
How close deportation is one of the circumstances that has to be considered. But if
there has to be, doesn't there? I mean, the whole point about Hardiel Singh, or at least the principal point about Hardiel Singh, I thought, but please correct me if I'm wrong, I may very easily be, is that the power to detain is a power in aid of potential deportation. Therefore, if the prospect of deportation isn't sufficiently in prospect, I'll use that neutral expression at the moment, then you can't any longer detain. Right. Now, the questions which assume that there is a deportation reasonably in prospect, sufficiently closely in prospect, then detention is permissible under Hardiel Singh. There will then be a question clearly whether instead it would be right to give him bail, and that depends on assessing the risk. There's no difficulty about that. The problem arises when the point has been reached where there is no longer sufficient prospect of deportation. Now, do you say that at that point it is still permissible, A, to give him bail, and B, to lock him up if he breaks the condition?
Try and express this as clearly as I can. First of all, Hardiel Singh is not only concerned with how great the prospects of deportation are. It requires all the circumstances to be considered. That includes questions like the risk of him absconding and the risk of him reoffending, which are two of the
Well, I wondered about that. I mean, where do you get this from? Hardiel Singh actually says, I regard the power of detention as being impliedly limited to a period which is reasonably necessary for that purpose. The period which is reasonable will depend upon the circumstances of a particular case, so that you may have to negotiate with Algeria or something like that. That may take a bit of time. But I don't think that there's any authority I know of, you can show it, which says you look at the person's particular risk of offending and so on.
Yes. Well, can I do exactly that then?
If there is one, let's see it.
I think the best place to go is lumber.
Right.
And that is in Authorities 2 at tab 9. It starts at MS 863. might just have a moment. I'll find the relevant part of this.
Have we actually got hard?
Yeah, 770.
Yeah.
Yes. The relevant part starts at paragraph 102. It's page 284 of the report. It's MS 902. Mr. Lumber, but not Mr. Mighty, had raised Hardiel Singh issues in this case. Lord Dyson at 102 referred back to the encapsulation of the principles he'd set out in the case of I. There's a summary there at 103 of period. And then at 104, he posed the question, how long is a reasonable period? And he quotes what he'd said in I. In my view, so starting about 5 lines down, in my view, the circumstances, that is, include at least the length of the period of detention, the nature of the obstacles which stand in the path of the Secretary of State preventing a deportation, the diligence, speed and effectiveness of the steps taken by the Secretary of State to surmount such obstacles, conditions in which the detained person has been kept, the effect of detention on him and his family, the risk that if he is released from detention he will abscond, and the danger that, if released, he will commit criminal offences. And then he says, so far as I'm aware, subject to the following qualifications, relevance of these factors has not been questioned. Then the qualifications they're set out, which is the nature of the relationship between risk of reoffending and risk of absconding. But to cut a long story short, the decision here in Lumber was that the two can be treated independently. They don't have to depend on each other. So that is, we respectfully say, authority at the highest level, that the risk of reoffending, the risk of absconding are relevant circumstances for the purposes of assessing whether detention is or is not at a particular time.
Is it the first 3 lines of 106 as well?
Yes, well, that is, yes, because that's going on to the detail of the argument that's being advanced.
That's a risk of absconding.
Yes.
But also of reoffending.
Reoffending.
Relevant to the assessment of the duration of detention that is reasonably necessary to effect deportation.
Sounds to me like a gloss
Yes.
on what Lord Brown, or Lord Justice Brown, or Mr. Justice Brown had in mind.
You mean Wolf?
Wolf.
You mean Wolf?
Oh, sorry, I mean Mr. Justice Wolf, quite right.
Yes.
Yes.
Yes, well, I've always worried about this whole thing, and in fact, I do recall raising the question of the relevance of bail in the course of the Lumber hearing, and of course we quickly parked whether bail came into the lawfulness or unlawfulness, or how it enabled one to assess that. That's what this case is about. But it definitely arose almost in that context.
Well, can I say, as far as what authority, the question of what authority there is concerned, this is it. Because this argument...
Logic of this is if you have 2 people sitting, waiting to be deported, and it becomes clear that there's not going to be a deal with Algeria or wherever within a reasonable time, in relation to one of them who has no record of past misbehaviour at all, he gets released, and the other, who might commit offences if he were released, sits there until what? Until what? He reforms himself, or what? What's the test become?
No, if it becomes apparent that the deportation isn't going to take place within a reasonable time, then I accept that the accepted Hardiel-Singh principles mean that both of them would have to be released. The difficulty arises where there is some prospect of deportation, but the timescale may be uncertain, there may be arguments about it, and if you have the two hypothetical comparators next to each other, the one who poses a risk of absconding or who poses a risk of reoffending may well be detained for longer than the person who does not pose either of those risks.
That I understand, but the present chap, there is in the case of the present person a ruling that there is no reasonable prospect of removal to Algeria, isn't there?
That is right, and that's why he can no longer be detained. But in fact, he'd not been detained for years.
Yes. But if just assume for a moment that point has been arrived at in the case of a particular detainee or potential detainee, can he then be granted bail on the basis that he's a risk of reoffending? He might well be such a risk, even though he can't be deported.
Well, can I invite the court to look at it like this? From February 2014, in B's case, I accept that the Secretary of State could not lawfully have detained him. That was
We've
science
reached the
decision.
Kabir point then.
No, we reached the Hardiel-Singh.
Oh, it's only
Reached the Hardiel-Singh
I see.
limit.
I thought that was I thought that from that date there was no prospect.
No. That's only the Hardiel-Singh limit.
Right, okay.
February 2014.
Yes.
We've reached that, haven't we, in this chap's case?
The Kadir limit has been reached. The Kadir limit was reached in December 2016 because then deportation came to an end. We couldn't do it, and SIAT said no more. So I accept that from there, the Kadir point was reached. We couldn't have continued bail beyond that. But everything comes to halt then. But the question is, what happens when you've reached the Hardiel-Singh limit in 2014? And the whole thrust of B's case is to try and get the court to look at it as if he was still being detained from February 2014 onwards. But the point is that actually he was on bail because it got him out of detention, and Hardiel-Singh was not offended.
But what would happen after 2014 if he were to break a bail condition? Could the first-tier tribunal or the sheriff detain him?
In theory, that might have been the outcome. I accept that.
What might have been the outcome?
That he would have been re-detained. But that would only have been lawful if whatever had changed that had caused him to be arrested had changed the Hardiel-Singh balance so that it was now once again Hardiel-Singh lawful to detain him.
But if you've passed the Hardiel-Singh point of no reasonable prospect of deportation, it can't, can it?
No, when the Hardiel-Singh limit is held to be reached, it's not a once and for all decision.
Well,
I mean, this is what I'm trying.
This is what you're trying to say. Yes, and we're trying to understand that. And doesn't it depend upon which of the four bits of Hardiel-Singh you're talking about? The limitations implicit recognised in Hardiel-Singh were, firstly, the detention must be for the statutory purpose of making or implementing deportation. That's number one, and for no other purpose. Secondly, it cannot be continued once it becomes clear that it will not be possible to effect deportation within a reasonable period. That's a maximum stopping place. The Secretary of State must act with reasonable diligence and expedition to bring this about. That's another condition. And then there's the fourth condition. And in any event, the detention cannot continue for longer than a period which is reasonable in all the circumstances. Now, I can see that the risk of absconding or reoffending could be relevant to that fourth condition, as to whether the period is reasonable in all the circumstances. But I don't see that it's relevant to the second condition, which is that the detention cannot be continued once it becomes clear that it won't be possible to effect deportation within a reasonable period. I don't see that offending or absconding is in the slightest bit relevant once you've reached that maximum period. I don't know, you'll tell us, the basis on which in February 2014 it was decided that the Hardial Singh limit had been reached. Was it on the basis of the no reasonable prospect of deportation within a reasonable time, which I think it was, or was it on the basis that in any event it's unreasonable to keep this person in detention?
We'll dig out the exact wording of that.
You get the point I'm trying to make?
I do get the point, but I can see that in the circumstances of some cases, one might be able to say that once that case had reached the Hardial Singh limit,
Or the main Hardial Singh limit?
yes. Well, if
No reasonable prospect within a reasonable time. Sorry, I didn't mean to interrupt you. I just
not
clarify what I was saying.
I think perhaps it might be better if I were to reverse the order of those conditions, because that is the opposite order was actually the way that Mr. Justice Wolfe explained it. You need to have the correct purpose. That's a Padfield type limitation, and ignore due diligence for the moment because that's not an issue. The period of lawful detention is limited to, can I say for shorthand, a reasonable period. So that's one condition. And if the reasonable period has elapsed, then the detention will become unlawful. There's a separate condition, which is in effect a gloss on that, which is to say that even if that reasonable period has not yet elapsed, but it becomes apparent that deportation cannot take place within that reasonable period, then you also have to release.
Yep.
That is actually the way that Mr. Justice Wolfe put it.
Did he?
Now,
Yes, but you see, that's the point I'm still getting at.
Yes.
If you've reached that final point, well then, it's not a variable feast. Whereas I can see that if you're just looking at reasonableness in general, it could be a variable.
That's right, and it may be that in this individual case, the likelihood of actual detention being unlawful was slim, unless there was some breakthrough with the Algerians. In the circumstance of this case, I accept that. But when you're looking at the question of principle, of whether the bail power has vanished, or whether, despite the fact that the Hardial Singh limit has been reached, at least for the time being, the bail power ought to continue to exist, you need to construe that in the context of a possible situation where actual detention may once again become Hardial Singh lawful, because there are cases where it can flip-flop between the two.
Yes, I mean, if I suppose in February 2014, if the decision was taken on the basis there didn't appear to be any reasonable prospect of Algerian conditions coming up to scratch, nonetheless, if 6 months later there was complete change, government and in prison arrangements, then you could deport.
That's right. And of course, in the circumstances of B's case, if we'd found out who he was and we had then got all the arrangements in place with the Algerians, then it could very readily have become Hardial Singh lawful to detain him.
Yeah.
So even in B's case, it could have changed if there was a breakthrough.
I mean, if you're, I don't know whether you're going to come back to Hardial Singh, but it would certainly help me actually to look at it, because my feeling is that Mr. Justice Wolfe didn't have in mind the Qadir type backstop, and on the face of what he said, he may be read as suggesting that the Hardial Singh point was a once and for all final point, and it's only Qadir that enables us perhaps to think in terms of some further possibility of deportation and a longer period within which circumstances may change.
Kadir...
Is that right?
No, Kadir, with respect,
Being
needs...
detained and liable to detain.
Yes.
Yes,
Fine.
Kadir needs to be considered separately, because Kadir is expressly on the basis that the Kadir limit can be long after the Hardiel Singh
Well,
limit.
exactly. That's what I mean. I'm not sure Mr. Justice Wolfe had that in mind.
No, he didn't. Mr.
He wasn't dealing with a situation where the relevant provision was liable to be detained as opposed to...
No, that's true.
Right,
That's
I
right,
mean,
he
the
was
issue we're being asked to focus on is the chap who has hypothetically passed the earlier of the two limits, the Hardiel Singh limit, but not the Kadir limit.
That's exactly
Yes.
so. Exactly
Right.
so.
But I mean, and the confusing thing is that he was, in fact, talking about the power of detention, which might make you think he was talking about the Kadir type.
But at least we now have the benefit of a lot more jurisprudence on this, and so that the ambit of the Hardiel Singh principles is now much clearer than perhaps it was just from the single judgment back in 1983, and we all have a much clearer idea of where it's going. And I should say that of course it's clear enough that it's now passed muster in Strasbourg because of the recent judgment of JN, which gave it rather a glowing review. And so all of this is now well established.
But, I mean, where's it best taken from, Mr. Tam? You do these things all the time. Is it now best to go back to Hardiel Singh, or, since it's been to the House of Lords in, or to this court rather, in
Lumber.
Do we look at paragraph 22 of Dyson in Lumber?
Lumber is
Convenient four-point summary.
Yes.
Take it from there.
Lumber is really as good a place as one can get. The modern state of affairs.
I mean, there was an issue in Lumber, wasn't there, about what the import of Hardiel Singh was, and it is resolved, as I understand.
Well, did we all agree? Did we all agree with that particular paragraph endorsing Re-I, the I case?
Not.
I think not expressly.
I think not all, but I'm pretty confident that there was a substantial majority endorsing that approach to Hardiel Singh. I think from memory that it was Lord Phillips who had some doubts as to whether or not that was the correct approach.
Well, you better give us the references, because
Well, it
those
looks
of
like
us who weren't in the case need to be satisfied that it's authoritative of the proposition in
Well,
paragraph.
it certainly looks as if Lord Phillips had, because if you look at 23, which follows immediately, obviously, after 22, you'll see a reference to him. But
Well, if by any chance you and your junior and those behind you can assist with working out exactly which twigs, which of the justices perched on in Lumber, with reference to whether it was a majority endorsement of the I approach to Hardiel Singh, that would be helpful for us. But we won't waste any more time. No, we won't spend any more time. It's not a waste of time, but we won't spend any more time on it.
I'm grateful. I think the only final observation that I would make on this is that we do actually, in our case, identify a case which was actually quite a notorious one called Abdi, where, to put it shortly, Hardiel Singh lawfulness did change from time to time during the period. But what I'll do is, rather than spend more time getting those references, we'll put those references together at the same time. So it's an illustration of that proposition that Hardiel Singh can flip-flop. Can I then, having dealt with the headline point that bail, the fundamental purpose of bail is to get somebody out of detention, the next point is that bail does have its place in the hierarchy of powers that control an individual and manage the risks which he poses whilst he's in contact with the immigration system. I think it's clear from our case what we say about this. At the top level, there's actual detention. It's, compared to the others, very effective, but it's expensive and it's actually rarely used. We've given some comparative figures. I think we found that there's something like 36 million tourist visits a year to this country, but compared to that, only about 30,000 in round numbers are ever detained during the course of 1 year. That's the number of people who start their detention. And the number of people who are actually in detention at any one time, that's immigration detention, is something in the region of 3,000. I think it's now a little bit under 3,000. So we are talking about relatively small numbers of people. There is one point in B's case which I should address. There's a reference to the number of people in immigration detention accounting for a third of the prison population. That, with respect, is not quite right. The prison population, again in round numbers, is something like 90,000. If you're going to compare like with like, it should be the number of people in immigration detention, 3,000, as against the prison population, about 90,000. That's a fairer illustration of the scale on which detention is used.
Whereas the 30,000 is the number of people who are taken into detention rather than the number that are there at any one time.
That's right.
I see.
Yeah. Bail, of course, is only available in cases where people have been detained. We accept, and we've set out in the case with our references, we accept that bail is capable of coming with more stringent conditions than temporary admission and temporary release. But of course, all of that makes sense because the people who are detained, that relatively small cohort of people, are the people who, in general, are considered to pose the highest risks. They are the more serious cases, as a matter of generality. It makes sense, in respect of those cases, that if they are to be released, that there should be available a wider range of conditions by which their risk can be managed. That's why we've referred to bail as the middle layer in the system of management of people who are in contact with the immigration system. And of course, temporary admission, temporary release can be used in the vast majority of cases, relatively light touch conditions. We now know definitely does not include curfews. So that is the third layer. And we respectfully say that if you are to construe the ambit of the bail power and what it can be used for, you do have to have an eye on where it is useful and how it is useful. And we respectfully say that the construction that we advance is entirely consistent with the proposition that it is there to manage more serious cases, but who don't need to be in detention at that particular time. The effect of B's argument, in contrast, is that when you have a serious case who's in detention, perhaps for a long time, and then he's been in detention for so long that his detention becomes unlawful, perhaps for Hardy-or-Singh reasons. That is precisely the point, if you look at the structure of the system purposively, that is precisely the point when one might think that it would be sensible for him to go onto bail with a relatively wide range of potential conditions to manage the risks that he poses, even though he can no longer be detained. But the effect of B's argument is that at that precise point in time, the bail power also disappears. And we respectfully say that that is a consequence which is at odds with the way in which the system ought to work, viewed from a purposive point of view. We say it obviously cannot have been Parliament's intention that such an odd consequence should follow from detention having gone on for too long. This actually links into our seventh reason, I will come back to this, which is that is actually precisely the approach that courts have been taking, even though this precise argument wasn't raised, but without that argument, it appears to be a sensible approach. And so we respectfully ask the court to follow that purposive approach.
Is it a principle of statutory construction that be sensible?
Well,
Useful.
I would always urge a court to be sensible in what it does, and I imagine the courts would always wish to be so. But to be serious, if one can see that there is a particular statutory construction which makes sense, if it works, if it's practicable, if it doesn't offend principles, and there's no unnecessary complexity, that is a construction which courts should be ready to adopt and endorse. Can I say, it is to this particular point that Kadir is relevant, and I think the court can now see why so much focus was placed on it at earlier times in this case, because that is what we'd been looking at in earlier hearings. Because the decision that the power of temporary admission can continue so long as the person is in contact with the immigration system and there is some prospect of that endpoint being reached, is one which is entirely of a piece with this purposive approach to the ambit of the bail power. And we respectfully say that it would make sense, looked at purposively, if somebody who's not in detention but on bail can be managed in the same way for the same duration of time as somebody who wasn't ever detained and is therefore on temporary admission conditions. I accept if somebody is on stringent bail conditions, that may be a source of complaint. But as I said at the beginning, that's a separate complaint. It's not a complaint, we respectfully say, which can be brought at the door of the principle of whether the bail power still exists.
So you're still on point 2?
Yes.
And you want us to look at Kadir?
No, I don't think I need to, and I'm conscious of the time, and Kadir, I sense that the decision in Kadir is quite familiar. So I don't need to do that at this stage. But I do need, just before leaving point 2, to draw attention to one paragraph in B's case. It is at MS 4251. In the core volume, it's tab 7, at page 27.
Paragraph?
It's paragraph 70, sorry.
Paragraph
first
70.
70, at the top of that page. It's a paragraph that's dealing with the remedies for breach of conditions. And the point that B makes here is that if there's a breach of bail, it could result in immediate redetention pursuant to the underlying continuing lawful authorization for detention. We respectfully say that that illustrates the misconception which I referred to earlier. There hasn't been a continuing authorization for detention in B's case for years. The whole point of this argument about the way you approach it is that in a case like B's, if he is being managed on bail, but he breaches his bail, then his detention may be reauthorized. He may be seen to be a case which needs to go back into that top category of cases. What there always is the power to detain him, but the management on bail has been a management of bail, not of detention.
By power to detain, you mean liability to detention rather than a power which couldn't necessarily currently be exercised. Is that it?
That's right. There's a power to detain, and the SIAC's decision in February 2014 meant that we could no longer exercise it. But in fact, we hadn't exercised it for years before that. The third reason is to address the anisminic lumber argument. The broad outline of this part of lumber was, that, as the court will recall, the situation in which an individual had his An individual had had his detention authorised by the Secretary of State, but pursuant to an unpublished policy which was unlawful. And that, because of anisminic, undermined the authority to detain, and that had the consequence that his detention was unlawful and it amounted to a false imprisonment. And that's the headline part of that of the lumber decision. We respectfully say that as far as anisminic is concerned and the approach, the strict approach to statutory construction, where a power to detain is concerned, all of that we can entirely accept makes sense in that context, because there somebody was being detained, and there are many statements in the law about the principles to be adopted where you're taking away somebody's liberty. But we say that the present context is a world removed from that, because this is a provision which is intended to be a remedial provision. It's intended to get somebody out of detention rather than to impose restrictions on somebody who would not otherwise be subject to them. In that context, there is no need to apply that strict approach to the construction of the bail power. Quite separately from the purposive arguments I've already made, as a matter of construction, it injects an unnecessary legal fiction into the construction exercise, and it actually restricts the availability of this ameliorating power. We've given in our case a couple of examples of hypothetical statutory language which would make absolutely clear that detention includes unlawful detention. We would also suggest this further possible example. Supposing the statute provided that a person who is detained is entitled to apply to the FTT, to the tribunal, within 24 hours for an order for his unconditional release. That is clearly an ameliorating provision. If our approach were adopted, that is available to everybody who's detained, whether or not their detention is lawful. But on B's approach, the effect is that somebody who's unlawfully detained wouldn't be able to avail themselves of that. The person who's unlawfully detained would have to take up a less speedy and perhaps less efficient remedy in order to get himself out of bail, out of detention. That example illustrates why there is no need to apply this construction principle to the bail power. And it also illustrates, in fact, why B's real complaint in these proceedings has actually always been about the fact that he was on bail rather than on temporary admission. And that's because he didn't like his conditions of bail. That is actually the underlying complaint. But as I've said, the legal issue that's raised by the Court of Appeal's judgment, the Court of Appeal's decision, is one which doesn't actually involve that at all.
But on your hypothetical example, there'd be an alternative remedy available.
Oh, there would certainly be an alternative remedy available, but the advantage of saying go to the tribunal is the tribunal is set up to deal with immigration cases. They know the field. And if you say, I'm detained, I would like to make use of this right to apply, within 24 hours you're in front of the tribunal, you're making your application before a tribunal knows exactly what it's doing. The person, on B's case, the person who's unlawfully detained couldn't do that. He'd have to go and apply for judicial review.
No, he'd have to apply for habeas corpus.
Well, you could apply for one or the other, but it's certainly not nearly as efficient as going to the specialist tribunal that's there set up, amongst other things, to deal with applications in relation to immigration detention.
I think you'll find that quite a hard submission to sustain.
The question is not whether it's efficient, but whether it's appropriate.
Well, the advantage of our approach to this is that actually both the individuals could go to the tribunal and make use of that remedy, and of course both of them would still have the option, if they wish to do so, to apply for habeas corpus or judicial review.
But I mean, your hypothetical example is interesting, Mr. Tanner. You're postulating a provision which says someone who is detained can make a short notice application for release. It would be a question of construction, whether it meant someone who was lawfully detained or somebody who was actually in clink. It might not be very difficult to come to the conclusion that it was the second. The difference with bail, at least the possible difference with bail, which is set against you, is that rather than release following, what follows is conditional release and the threat of return.
That's right, and that is exactly my point, because the complaint. Well, sorry, if I can just actually do this in stages. The first one is we respectfully agree it is a matter of construction, because this argument is B's argument that you must construe the statute in a certain way, and the illustration that we offer is one that that demonstrates that actually sometimes that is not sensible, because there are times when you would want to make sure that the remedy, and it is a remedial provision, the remedy is available to people who are both lawfully and unlawfully detained. So the principle which B prays in aid is not one which is actually particularly apt to a situation where the power in question is one that will get you out of detention that you don't want to be in.
Well, that all hangs on your expression of bail as a remedial concept, and in a sense, of course, it is. It's better to be on bail than it is to be locked up. But if you can't lawfully be locked up, you don't actually need that as a remedy, do you?
Well, the second part of the submission I make about this is that, as far as the conditions are concerned, if you don't like the conditions, you have a separate complaint to make. It's not about the principle of whether you can be bailed to get you out of detention. It's the stringency of the conditions which you say is inappropriate to your situation. Can I then move on to reason 4? It's the impracticability section. We say that with respect it was rather dismissively treated by the Court of Appeal. But just as in the purposive submissions, we say Parliament must have intended a scheme that is workable, rather than one which is beset with complexities and procedural niceties. It's frequently said, and I think it's been said by this court, that the immigration system is already impossibly complex, and there are difficulties from that. One thing that is clear is that B's argument would lead to the conclusion, or would lead to the result, that further complexity is injected into the system. That is not a conclusion which we respectfully say the court should be quick to adopt. The particular problem, I'm going to try not to repeat things I've already said. One particular problem is that it makes the lawfulness of detention a jurisdictional issue for the FTT before it can either grant or continue bail. It also flies in the face of all the repeated dicta over the years that the FTT has no jurisdiction to decide on the lawfulness of detention. If this court were now to hold that it does, one can see the consequences for the FTT. And in fact, perhaps I might say that holding the Secretary of State's brief, it's the Home Secretary, and if the court were to say that the FTT has a jurisdiction which hitherto the courts have said it doesn't, the Ministry of Justice might have some views about that, but I can't represent their views to the court.
Well, would that depend on where the positive detention might be? I mean, who runs the immigration detention centres? Does the Ministry of Justice run those?
No, I'm thinking more in terms of the burden on the tribunal in having to deal with complex, sometimes very complex Hardy-Singh questions, just to work out whether or not they can grant bail. And that is not something which should be lightly imposed on them. The problems relating to the consideration of lawfulness. If I can start with Hardy-Singh unlawfulness, because that is the immediate context of this case. It is often a question of great difficulty. In fact, B's own case illustrates this. In February 2014, or the hearing actually took place in January, when SIAC considered whether detention would now be Hardy-Singh unlawful. It was also linked to the question of what the prospects were of deportation to Algeria. You'll have seen the two sides of that decision. And of course, those two issues are linked. That was 2 days of argument before SIAC, leading to its judgment. As I say, it has implications if the tribunal were to do this for the practicability of their decision-making. At any rate, even where the person is detained and the court is considering whether the Hardy-Singh limit has been reached at a particular time, the question is of great difficulty. And there are illustrations of that. I'll come back to the illustrations when I deal with reason number 7. But the difficulties, we respectfully say, are magnified if you require the tribunal to ask the question in relation to somebody like B, who had actually already been bailed for a long time. How do you deal with the question of whether it would be lawful to re-detain? It's rather artificial, in fact, to ask that question when nobody was proposing to re-detain him.
Well, why does the question whether someone's in detention or not impact on the difficulty of deciding whether there's a reasonable prospect of deporting him or her?
It may not have an impact on that precise question, but the Hardy-Singh factors, as set out by Lord Dyson in I, and then he quoted it in Lumber, include things like the conditions of his detention whilst he is detained. That can have an effect on whether the reasonable period has elapsed. And in fact, the next point that I'm about to make is that what B has not done is to identify what exactly is the Hardy-Singh question that would be asked in the case of somebody who is not in detention, who nobody is proposing to detain, and who has in fact been on bail for a long time. What question is the tribunal to ask and answer in order to decide whether it has jurisdiction to continue bail? Is it whether, if the person had hypothetically remained detained until now, that detention would by now be Hardy-Singh unlawful? Or is it the question of whether, having been on bail until now, would it now be Hardy-Singh unlawful to return him to detention? Those are two very different questions. We pose them very clearly in our case, and as far as we can see, B has not answered that. The formulations are well, in the case of the first one, actually impossible to answer because you just would not know. You could not work out what would have happened in detention, including conditions. So, so that is not actually viable. But the second formulation could also be unanswerable, or at least very difficult to answer, not least because the Hardyal-Singh lawfulness of your detention also depends in part on why you are detaining the person. So, for example, in the example we've already dealt with, supposing in B's case there was a breakthrough and we knew that he was going to be removable, say, within a matter of weeks, it would then be Hardyal-Singh lawful to detain him. That is a sort of thing which a tribunal would be being asked to consider entirely hypothetically, just to decide whether or not bail could in fact be maintained for a further period. That's a burden which should not be lightly imposed on them. I have already dealt with the proposition that the tribunal has been repeatedly held not to have jurisdiction to decide the lawfulness of detention, and it would be a major departure from that for this court to hold the contrary. B also makes the point, well, he makes a number of points which I should perhaps address at this stage. The first is that it's fanciful to suggest that somebody who is asking the tribunal to consider a question of bail will put its jurisdiction in issue. There are two answers to that. First is if it's a jurisdictional issue, it's a jurisdictional issue, and that can't be waived by an individual just failing to raise it. But in any event, B's own case demonstrates precisely the context in which it can occur. If the Court of Appeal was right, then what could have happened before SIAC in February is 2 days of argument about Hardyal-Singh and prospects of removal in order to decide whether bail should continue or should be terminated. And that was what B was in fact asking the SIAC to do, but did it in 2 stages. And that's the sort of thing which people could be expected to do before the tribunal. The second point that B makes is that the tribunal already nearly does this. And B points to materials such as the guidance to immigration judges that they should think about the lawfulness of detention when they're deciding whether or not to grant bail. However, there's a key difference between what the tribunal does do now and what the tribunal would have to do if B's argument were correct. As things stand at present, the tribunal can think about lawfulness of detention because the closer that somebody gets to unlawful detention, the greater the call for bail to be granted. That's a common sense approach which one could not possibly complain about. But what B's argument is very different. It is that if you reach the point of unlawful detention, then the tribunal cannot grant bail. It would have to hold that it does not have the power to do that. That is, first of all, it's counterintuitive, and secondly, that is an example of injecting complexity. Our approach simply does not have that problem at all. A third point that B makes is that if there is a problem with the tribunal deciding itself whether detention has become unlawful, then the answer is for the individual to launch concurrent judicial review proceedings so that the Judicial Review Court can consider and decide that, that question. In a sense, of course, I ought to welcome that because it sounds like a job creation scheme for lawyers. But in a complex immigration system, we respectfully say that's not a particularly appealing approach.
Have you got the reference to the guidance?
Yes,
I know you're not raising it, but
yes.
it's just helpful to have the
Give me
reference.
just a second, I can turn this up. It's in Authorities Volume 11, and the latest version, I think, is at tab 135. It's MS 4126.
Thanks very much.
And the fourth of the points that I think I should address is that there has not been a problem to date. Well, there's two answers to that. One is that this is a relatively novel point, and the Court of Appeal's decision does depart from previous understanding. But it's, if there is guidance that if detention is becoming unlawful, grant bail, that's not going to cause a problem. However, if this court were to endorse a position that if detention is becoming unlawful, you must refuse bail because you've got no jurisdiction to grant it, then that is a point at which problems will start to arise. So the B's point is not one which can carry any weight.
Does the tribunal have power to impose temporary admission conditions?
I don't think so. We'll just check the statute, but that is for
The immigration officers.
immigration officers. So I highlight those examples of the impractical consequences of B's construction and the Court of Appeal's decision. That's reason 4. We say that if you analyse them, and indeed the other examples which we've given in our case, you will see that they're actually more than just impracticability. They are substantive questions of the way in which the whole system would function. Given the difficult questions that have to be asked and would, on B's case, have to be answered sometimes by relatively junior immigration officers. And I think there's actually one final point I should make in relation to this before I leave reason number 4, and that is that it might be argued against me that Hardy or Singh could, even if it's not easy to deal with, could at least be dealt with at the time that somebody is granting bail or renewing bail. But that is not the only point at which the question could arise on B's approach. And the reason is this: you might have a situation in which somebody was granted bail and nobody took the point at the time. And then later, perhaps years later, somebody says, oh, well, actually, I was falsely imprisoned because of the curfew that was imposed on me. That curfew was imposed without any power because at the time it was already Hardy or Singh unlawful to detain me. And therefore, there was no bail power and bail should never have been granted and the condition should never have been imposed. And so you could get retrospective litigation challenging a grant of bail that was a long time back. And by that stage, it would be very difficult indeed to work out whether or not the bail power did or did not exist. In other words, unnecessary complexity. Can I then turn, please, to reason number 5, which is that other than Hardy or Singh, there are other types of unlawfulness. Hardy or Singh is the context of B's own case, and I've already dealt with the point that Hardy-Singh unlawfulness itself can flip-flop one way or, and the other. But there are other situations in which there are even more unfortunate results. Can I take as two examples the cases of Lumber and Kambadzi? Now, their facts were actually about detention, but they do identify types of unlawful detention other than Hardy-Singh unlawfulness. In Lumber, detention was under the unpublished policy and so was unlawful. But what this court did do was to consider the hypothetical case of the person in Lumber's situation who was detained under the published policy. The decision was that that person would have been detained in the same way, and that was the foundation of the nominal damages result in Lumber. If one looks at the latter situation first, the person who's lawfully detained, but the Secretary of State thinks that he should be on bail, but not on temporary admission, there's no difficulty on anybody's case because that person can simply be bailed, and there's no argument about the lawfulness of doing so. But if one thinks for a moment about whether it makes sense to impose B's case on the person in Mr. Lumber's situation, we say that one gets to a rather absurd result. His detention was in fact unlawful, but this court decided that he could have been lawfully detained, so much so that he actually suffered no loss from his unlawful detention and got no money. So as far as his detention is concerned, his case was materially identical to that of the person who was lawfully detained throughout and was unobjectionably bailed. The consequence of B's argument is that if the Secretary of State wanted to bail Mr. Lumber, she couldn't have done. There was no jurisdiction to do so. Even if the Secretary of State didn't want to keep him in detention anymore, the only option, according to B, would have been temporary admission. Now, given that these powers are provided in the public interest to manage the risks posed by individuals, we say that that is not a consequence which makes any sense whatsoever, but it is the inevitable consequence.
Could she have remade the decision to detain?
Well, what she...
And then immediately granted bail?
We would say, I mean, if that situation arose, then we would say, yes, what she would have had to do was to release him from his unlawful detention.
Remake the decision.
Well, that might lead to arguments, but she would, to be safe, she would release him, perhaps immediately re-detain him, and then release him on bail. That's jumping through a lot of hoops to achieve the same end. So there's a difficulty there. And in fact, now that I've shown you Lupepe, you can see the sort of argument that might be run, even if that were to happen, because that's a sort of what happened in Lupepe, that he was re-detained in order to trigger the bail power. It was never intended that he should remain in detention, that he should always be released immediately on bail. But then the argument was run, well, that detention was unlawful because it was a breach of policy, and you couldn't bail me. So this sort of litigation is not by any means a fanciful prospect. Or to take the example of Kambadzi. Kambadzi, the court will recall, was the case where the individual was continuously in detention throughout. But the problem was that detention reviews were missed from time to time. This court held that each detention review authorises the next period of detention. If you miss a detention review, the effect is that the following period of detention is unlawful until there is once more a proper detention review. This court, of course, recognised, just as in Lumber, that if the missing detention reviews would have been decisions to detain, to continue detention, then the individual probably suffered no loss and would get no money. So far, so good. But if you think about what B's argument means in that situation, if at some point the Secretary of State said, well, this has gone on for long enough, I want to release you on bail, if it were the case that a detention review had been done and detention was unlawful, no problem. If it turned out to be the case that a detention review had been missed, then even though the individual had suffered no loss as far as false imprisonment is concerned, would get no damages for it, the Secretary of State would simply have no power to bail at that point. There are, again, there is the possibility that if the Secretary of State then jumped through the hoops, that the bail power might arise. So the Secretary of State would have to do a new detention review.
That's if you spot it at the time. Your point is that you might not.
Yes, exactly. Well, there are 2 points. The first is that if the Secretary of State does a detention review and says, I'll continue to detain and now I'll immediately bail you, well, that might jump through the black letter hoops. But of course, there's the possibility of a challenge being brought to that detention review on the basis of, if you always intended to release me, then you couldn't properly have decided on the detention review to detain. And then the second problem is if you do it retrospectively, if somebody much later on goes back and says, oh, you missed that detention review, you actually had no power to bail me at all, it's too late to fix it by then. And then, of course, that illustrates there's one further potential problem from that, which is that that might lead to people actually being detained for longer in order to make sure that the hoops can be jumped through to lawfully have him, lawfully release him on bail. That's to say, if it's realised that a detention review has been missed, there might have to be a very careful detention review to ensure that continued detention would be justified so that there could be a release on bail. And I think the final point that I would make on this is the case of accidental redetention. You might have an individual who has been on bail. Nobody's complaining about the fact that he's on bail or the conditions of his bail. But for some accident, he's redetained, and the mistake means that that redetention was unlawful. B's argument would have the consequence that he couldn't be re-bailed on the same conditions. The power would simply not be there. Again, in theory, one could imagine the Secretary of State jumping through the hoops. You'd have to release him from his unlawful accidental detention and then redetain him again, hopefully lawfully, in order to put him on bail. But really, none of that makes any sense. May I then turn to reason 6? The proposition is very simple. The old cases are a red herring. Learned friends for B gently mocked us by saying that we devoted 11 pages of our printed case to these old cases. There's a reason for doing that. Because we say that they're a red herring, we thought that it would save time if we set out what they decided and why they're of no relevance in greater length, so that we didn't have to trawl through in detail printing that's in old typefaces and difficult to read and language that is archaic and difficult to understand. So what I will do is to deal with this as shortly as I can and invite the court to look at our printed case for the detail of the cases on which we cite to illustrate why they are of no assistance to solving the current problem. To put it shortly, the Court of Appeal, as we've seen, relied on these cases as supporting the proposition that bail is the same as detention. Now, there was a time when that was true. I have to say, I think in the course of preparing for this hearing, this has probably been the most fun part of the work that we've done, to go through and look at all of this old stuff and see the history. But what we discovered was that that time and that approach to bail has long passed. By the time of the 1971 Act, which was just before the Bail Act 1976 for criminal purposes, the modern concept of bail being the antithesis of detention was already well established. And so when Parliament provided the power to grant bail in the 1971 Act, that must have been based on the modern concept of bail. The history of this we have set out at paragraphs 9.4 to 9.6 of our printed case. That's MS 152 to 153. Can I just draw attention, without turning them up, the materials which we cite for that? There's Stephen on the history of criminal law. That dates back to 1833, that publication. Authorities 11, tab 138. It's MS 4185 at 4186. We've also cited Holdsworth's History of English Law. Now, I have to say I wasn't able to find a date for that, but I did find that he was Vinerian professor from 1922 to 1944. So it's that sort of time that he's writing. That's at Authorities 11, tab 131, MS 4014, and the passages concerned are 4015 to 4017. And we also draw attention to the Home Office report that was part of the preparatory work for the Bail Act 1976, the criminal bail. That is found at Authorities 11, tab 132, at MS 4018. Without turning that up, can I just address one point that is made by B? B says that report recognised that much of the then practice in criminal bail still reflected the old concepts, that the individual was in the custody of his sureties and therefore still in custody. A fair reading of that report underlines that what the working party was referring to was the procedure that reflected that. What it did not say was that the concept of bail in the early 1970s was still the old concept of bail. It had long changed, and I will come to an authority that demonstrates that. We've referred to some materials about the historical status of somebody who was on bail. That's at paragraph 9.5 of our case. We refer, in addition to Holdsworth, to Matthew Hale, which is Authorities 11 at tab 127. It's MS 3969. In our printed case, paragraphs 9.7 to 9.15, which is MS 153 to 157, we refer to three old cases. They are the Queen against Butcher, or probably the King against Butcher, Mitchell and Mitchenham, and Foxhall and Barnett. And we set out in our printed case at some length what those cases decided and how they reflected that old concept of bail, which was that the bailed person was in the custody of his bail. That's the phrase of his bail, who were the people who effectively had him in custody by proxy. We also refer at 9.16 to Highmore's Digest. So Authorities 11, tab 133, 130. And we have actually put in a substantial quote there because the soundbite which the Court of Appeal got was, with respect, misleading. Highmore was discussing the difference between bail and main prize, and it's main prize that really is our modern concept of bail. For the proposition that by the early 1970s, the old concept of bail had long been left behind, we refer to two authorities in particular. One, which I don't need to turn up, is the 1848 Criminal Procedure, which allowed the court granting bail to dispense with sureties. We deal with this at 919 to 921 of our case MS 157 to 158. But what I think I should show you is the case from 1903, which demonstrates beyond all doubt that by then bail was no longer regarded as actual imprisonment. And that's a case of Yusuf Uddin, a Privy Council case. You have it at Authorities 2 tab 15, which is MS 1094. MS 1095 in the right-hand column is where the report actually starts. And the facts of the case, if I can start at the beginning of the report of the judgment, Lord Macnaghten said the question in the case was a very short one, namely, is a prisoner who has been released on bail under imprisonment still, so long as he is out on bail? A more apposite question one could not hope to have formulated. And the facts were that there was one, Mr. Chunder, who was convicted of an offence. And then on the 18th of September 1895, the officiating resident at Hyderabad obtained a warrant to arrest the appellant, Mr. Yusuf Uddin, on the charge of having abetted Mr. Chunder. And then if you go down to the bottom of that column, 3 lines up, he, that's to say the superintendent of railway police, endorsed the warrant to a chief constable who arrested the appellant at one of the stations on the railway on the 28th of November 1895. And there's a discussion about the status of the railway in territorial terms. 2 days later, on the 30th of November 1895, he was released on bail, undertaking to appear on a day named at the court. Skipping a few lines, on appeal to Her late Majesty, the order of the Chief Court of the Punjab was reversed. The warrant of the 18th of September 1895 was cancelled, and the proceedings were set aside by an order in council dated the 3rd of August 1897. In July 1898, so just under 1 year later, the appellant filed his plaint in the present suit against the Secretary of State for India, alleging that the warrant of September 1895 was issued without jurisdiction and that the charge against him was unfounded. If you can go down that column to just below halfway, you'll see the argument. Before the board, counsel for the appellant raised a clear and simple issue. They admitted that malicious prosecution was involved. It was false imprisonment or nothing. Again, they admitted that if the imprisonment ended on the 30th of November 1895, the suit was time-barred, for the period of limitation is 1 year from the termination of the imprisonment. But their contention was that the imprisonment continued until the warrant was set aside, so long as the restraint of bail lasted, and it might be taken that it lasted until the warrant was set aside. The appellant, they said, was not a free man. He was even liable to be actually imprisoned through the action of his surety, or possibly by reason of the intervention of the government. All that might be very true, but the learned counsel did not cite any case in support of their contention. The whole weight of authority was the other way. Nothing short of actual detention and complete loss of freedom would support an action for false imprisonment. There's then a citation of Bird and Jones, and then about 8 lines down the right-hand column, the conclusion was set out. In their lordship's opinion, it was perfectly clear that the appellant's imprisonment did not last one moment after he was liberated on bail. The very object of granting bail was to relieve him from imprisonment. Immediately after his liberation, he might have brought a suit for false imprisonment and possibly might have succeeded in obtaining some damages. Having failed to bring his suit within 1 year, he's now barred by limitation. Similarity of some of those concepts with what's discussed in our cases on immigration bail is actually quite striking. It is absolutely authoritative, we respectfully say, for the proposition that certainly by 1903, bail was no longer regarded as actual imprisonment.
Might be said that that was for the purposes of the tort of false imprisonment.
Well, there's no, I accept that's the context of the decision in the case, but there's no such limitation found in the language used by Lord Macnaghten. It is a bare statement. The imprisonment had finished. He wasn't in detention anymore.
No, he wasn't, but he might have been, mightn't he?
He might have been.
He'd been arrested.
Yes.
And he was in the custody of the court for 2 days, I think, and then the court decided that he should be remanded on bail rather than in custody, but they might, of course, have made the opposite decision.
They might have done, and if they had made the opposite decision, he would have remained in custody, yes. and the detention would have continued, and so the running of the limitation period wouldn't yet have started.
I absolutely understand why you say that this demonstrates that by 1903 a person on bail wasn't regarded as being in custody, but the proposition you have to deal with isn't that B would be in custody. It's that the power to grant bail assumes that he could be in custody.
Oh well, yes, that I accept. That's a different issue.
Yeah.
But
these cases don't have anything to do with that issue, though, do they? I mean, there's no. It's very unlikely that the change in the concept of bail to which you're referring meant that you could now unlawfully arrest people and then grant them bail. They don't go to that point at all. And I find them difficult to relate to this case.
Well,
I know the Court of Appeal related them, so it's not your fault.
Yes, the Court of Appeal found some solace in this, yes. And we respectfully say it was red herring. This is really the 16th, 17th, 18th century cases. They're just not on this point at all. They can't be relied on at all because the concept of bail then was different. If you need to find out what it's like now, you need to look at modern cases. And by 1903, you have this case. It's not just detention for the purposes of false imprisonment, but it includes a recognition that it was not imprisonment, notwithstanding the possibility that he could have been rearrested whilst the warrant remained alive. And that's the situation we have now, where the power to detain continued to exist. And so there was that theoretical possibility of an arrest for breach of bail and so on. But what is crystal clear is that being on bail was not detention.
No,
and the concept...
What you're doing is knocking out the bulk of paragraph 33 of the Court of Appeal, is that right?
Yes.
And you make the point, I assume, that having knocked it out, you've knocked out one of the reasons why they were saying, in the first sentence of that paragraph, the power to grant bail presupposes the existence of the power to detain. And then they go into the old cases.
Yeah, that's right. And of course, that first sentence itself identifies something which is clear in this case. The power to detain was always there. And it's the fact that it couldn't be exercised. And really, none of this helped the Court of Appeal at all.
Well, that looks like a very convenient moment, Mr. Tan. Very well timed. We'll look forward to hearing from you further at 2:00. Court is now adjourned.